Thank you, and thank you to the organisers, to Valentina. It's a real pleasure to be here today. So I have 20 minutes. It's 11:42, so I'll stop at 12. I'll stop till midday. So, in some respects, the ESM treaty has been looming heavy in my life for the past 5 months, because I'm a member of Mr. Pringle's legal team, who's been challenging the European Stability Mechanism, first before the High Court, then the Supreme Court, now the Court of Justice. It started pretty much in May, the High Court was in June, and the Supreme Court was in July. The Court of Justice hearing was on the 23rd of October, and the judgment is out on Tuesday. So it's been going very, very fast. At the same time, the observations I'm making today are my personal ones, but a little bit I just thought to share the experiences of what it's like to try and enforce some measure of democracy and accountability before national and European courts. One thing that this experience taught me, and that the discussions over the past the day and today have shown, is that the issue of the financial crisis really has raised a number of very important democratic principles. And it's all very beautiful to have provisions in treaties saying that we're a union founded on democracy and the rule of law, but it's in the moment of crisis, as we know, that it's tested. And now is the time when the Court of Justice will have to say that, well, actually, does this mean, do these words in the preamble, does Article 2 of the Treaty of European Union, is it lip service, or does it mean what it says, or at least what we suggest, or it should say. So today's menu, basically 3 things. First, just very, very briefly, because at this stage you'll be well aware of the legal framework governing the ESM. 2, I'll just discuss about the Pringle case and the compatibility of the legal framework with obligations under union law. And 3, which is a brief thought on what the impact of the legal framework is on the state of European democracy. Conclusion. So, this I'm going to go through very, very quickly. We know that obviously there has been euro crisis, and that it has been claimed to threaten the very survival of the euro, the single currency, and there had been a succession of European Council meetings, in which case where the European Council would decide that what is the best way to proceed. Following a report by the task force and conclusions of a European Council meeting in October, it was decided to create a permanent crisis mechanism, and in December 2010 there was an agreement that it would be necessary to amend the Treaty on the Functioning of the European Union. So basically, we're in a crisis, and the question is, how are we going to respond, create a stability mechanism? So what was the legal framework at the time? Well, we have the EMU, and what is the EMU? The EMU, as negotiated and enshrined in the Maastricht Treaty of 1992, which was the subject of much negotiation and of referendums in Ireland and in Denmark. So a key aspect to economic and monetary union was the idea of price stability. That was something which is fundamental. And if one looks at all the records of the negotiations at the time of the convention and the intergovernmental of the treaty, price stability was key. Horst Kohler, the State Secretary for Germany, was saying that it's really important from the outset that the markets know that each member state is responsible for itself. That is the credibility of the euro system depends on it. The Monetary Committee said that budgetary discipline must be one of the foundation stones of EMU. The treaty should lay down that neither the other member states nor the community stand behind any member state's debts. So Article 125, which became the no bailout clause, wasn't there by accident. It has been the process of negotiation by member states. It represented the democratic will of the member states. It was approved by referendum, in particular in Ireland. So if one looks at the Commission's own website on economic and monetary union, and there's a section called Myth and Facts, and one of the myths is that bailouts would be possible. And it was saying some people might tell you in scaremongering that one member state may have to be responsible for the debts of another and assume their liabilities. Myth. We have put in an express clause. This could never arise. Don't worry, this is... We also have, of course, Article 123 of the TFEU, which prohibits the ECB from providing overdraft or credit facilities or direct purchase of debt instruments. So this is the legal framework we have, an EMU debated in a treaty provision enshrined with a no bailout provision. And now we have a council conclusions in October and December saying we need to set up a bailout fund. So what do we do? So I accept that the European Council could be considered to be in a little of a legal quandary. There is Article 122 of the TFEU, which had served as the legal basis for two previous mechanisms, the European Stability Facility Mechanism and the European Financial Stability Facility. But it was doubted whether 122 could constitute an appropriate legal basis. And the reason for that is because it was really, from read in conjunction with 125, it really looked like a kind of force majeure type financial assistance, not financial assistance for the kind of things that were beyond control of the member states. So how to create a bailout fund? So we said, okay, we'll amend the TFEU now, it depends, there's two interpretations of this. Opinion is divided on the subject. We say that the European Council, and if one looks at the European Council decision, it says that in order to establish a permanent stability mechanism, a treaty change is required, or let us see what treaty, basically the European Constitution made a reference to that being a requirement. Now, in the context of the Pringle decision, they were saying that amendment doesn't constitute a requirement. It's there to confirm an entitlement to a bailout. So the first point was that there was a decision to amend the TFEU, just to clarify that how a bailout would sit with the EU legal order. And the second idea was to create, by intergovernmental treaty, the ESM outside the framework of the Union legal order. So outcome, we have the European Council decision of 25 March 2011, which was added in Article 136, paragraph 3, which basically said that member states are now authorized to establish a permanent stability mechanism subject to conditionality. The ESM treaty was signed first on the 11th of July, and then ESM2 came on the 2nd of February 2012, with 700 billion euro as authorized capital stock, and that could be used as security. So, and up to, I think there was a limit for the first 5 years, but after that, it could create security for trillions of euros. It was initially proposed to enter into force into July 2013, after the entry into force of the European Council decision, which was to come into force on the 1st of January 2013. And then they decided to advance the date to July 2012. So the point is that the ESM treaty was then to come into force before the European Council decision, which was adopted because it was, in its own recital, thought it was required to establish a mechanism. And obviously there's been legal challenges in Germany, Estonia, and in Ireland. Sorry, that's just make it clear. So the question is, in the compatibility of the case, was raised in the question of Pringle, and that's case C370. 12. If our full observations submitted on behalf of Mr. Pringle are available on the website and called A Tale of Two Treaties. So you'll see what the details of exactly what the arguments were, as well as the transcript of the oral presentation. But very, very briefly, the main arguments against the ESM, or against the legal framework governing the ESM, was first that it was a breach of union competence, because it was done as an intergovernmental treaty. We said that monetary competence is an exclusive competence of the Union, so member states have no scope of action at all. To the extent that it's economic competence, it's a shared coordinating competence, and that's clear if you look at Article 2.3 TFEU, and also if you look at Article 4.1 TFEU, which says basically that anything which isn't in 3 or in 6 is a shared competence, and economic policy doesn't feature in 3 and 6. And basically, if one looks at the nature of the economic policy competence conferred on the Union, it becomes clear that things relating to the euro are actually quite central to it. If you look at Article 119, Article 120, it becomes clear that the euro, maybe it's not surprising, this shouldn't be such a big sentence, but is actually a cornerstone of the EMU. Its place is in the core of the treaties. So our argument in this case was that it shouldn't be hovering outside the Union legal order. So, A, there's the monetary competence, which is exclusive. 2, economic competence is a shared coordinating competence, and a lot has been already been transferred and exercised in relation to the provision of financial assistance. And just to say that the very existence of the European, the EFSF and the EFSM, that they are all referred to the union legal basis, shows that it's something that has been exercised by, it's a competence which has been exercised as a competence, although that's open to discussion.
Only one of them was adopted under that.
Well, but the other one referred to it. The EFSF referred to it. Like, if you look at the framework agreement, it was saying that.
It still was an international agreement.
But yes, yeah. And thirdly, in relation to Article 5.1 TFEU, it says that economic coordination. But for example, even if the EFSF was wrong, it doesn't mean that the ESM is right, or vice versa. Just we didn't get there in time. Article 5.1 says that economic coordinating competence must take place within the Union. So the main claim here was that it's an anathema that international entity which is coordinating financial assistance to safeguard the euro. So it's not just the IMF, it's not just giving financial facility, it's not just a bank, it's there to safeguard the single currency, that should be outside the Union, and that was the competence argument. And then there's obviously case law by the Court of Justice about special duties of action and abstention, the whole relationship between member state legal order and that of the Union. 2, we said that there was a breach of the no bailout provision. Member states assuming each other's commitments constitutes the whole, clue is in the title, it's a bailout mechanism, and there's a no bailout clause. Also, if you look at Article 25.2 of the ESM, it arguably sets up in itself a guarantee mechanism, because basically it requires member states to pay in money into the fund, and if one member state can't pay in their contribution, then then a new capital call comes, and the other member states have to guarantee the other member states' contribution. And if that isn't a bailout, or if that isn't a guarantee, then someone could tell me what is. We argued that if there's a breach of a no bailout provision, then that applies to member states regardless of the legal framework. If you're allowed to do, if you interpret Article 125 in a different way and say, well, actually it's more restrictive, well, that's one argument, and then you say, well, you're entitled to do it. But if you say that Article 125 prohibits bailouts, then it's not an answer to say, well, then it's okay, we can do it outside the Union. And also, we argue that there's not a legitimate shelter from independent legal personality, because a number of member states in the Court of Justice had submitted that, well, even if it's not allowed for member states, this is the ESM, it's not us, we're different. But there's quite a lot, of course, case law on this, where the Court of Justice has consistently held that if member states have decisive control or decisive influence over an entity, then they mustn't tolerate breaches either directly or through the intermediary of an entity which is controlled by them. And that was stated in particular in the Amsterdam Bulb case. Then the final part of the challenge, there's lots more, but basically related to the ESM in general principles. We said that it was breaching non-retroactivity because the European Council decision said that a treaty change is required. It was only coming into force on January 2013. The ESM treaty is already in force now. Required, we thought meant required. Moreover, if one looked at the ESM's own question, So basically we're saying that this argument that it's only a confirmation is at odds with the recitals. And it's just saying that even the ESM seemed to consider that it was founded on the European Council decision. If one looks at it on its own website, they were saying, well, what is its legal basis? And it referred to the European Council decision, which wasn't in force. Some days before the Court of Justice hearing, that was removed, and a new version came up without any mention of the European Council decision. But again, it indicates that the goalposts were changing. And perhaps most fundamentally, and perhaps this is the point which goes to the essence of the challenge, that arguably that by creating an institution outside the EU legal order, the question was, and subject to international law, does it ensure effective judicial protection? We know Article 37.2 says that the ESM shall enjoy immunity from all forms of judicial process, which is pretty broadly drafted even by international law institution terms. And of course, there's questions over the ECJ competence. And then there's a question of equality, which I want to address now. And then there was one other question, well, in relation to the competence of the institutions. The question is that to what extent would the Court of Justice have competence over to judge disputes? Because the treaty itself, which refers to the European Council decision, but the ESM treaty also refers to Article 273. And Article 273 says that it relates to disputes between member states. And the question is that if a dispute between one member state and the ESM, does that constitute a dispute between member states? There was also a question about the inappropriate use of the simplified revision procedure, because Article 48(6) only permits amendments that amend Part 3 and does not increase the competence of the Union, and there was a question as to whether that was indeed the case, which I don't have time to go into here. So, the last 2 minutes, the question is that what exactly is the impact of this legal framework on the EU legal order? And the first point I would like to say in relation to this is that these comments are regardless of whether the court holds that it's compatible or not. The question is that what exactly is the impact of the legal framework? The first one is that arguably it's nullifying an express provision of treaty law. And by that means that, well, we said that there's a Maastricht Treaty that enshrined the principle of no bailout, and if one is amending that, all very well, but then it should be amended by a proper treaty amendment, because it reflects a provision which represents the will of the people at the time. Two, arguably, the way, by doing it outside the Union, as Professor David said yesterday, permitted the use of the simplified revision procedure, because had it been done inside the Union, that would be clearly an increase in the competences. So by managing to do it by outside the Union, one has been able to use the simplified revision procedure, and that obviates the requirement for the full convention and the participation of national parliamentarians. And yes, it's faster, but it's arguably also less democratic. Then there's the circumvention and contradictions arguably are detrimental to the integrity of the EU legal order. And basically what the submission here is that in addition to the circumvention of the ordinary revision procedure, so that now you can use the simplified one, you could also say that by placing the ESM outside the Union, there's an attempt to circumvent the prohibitions on bailouts or on bond purchase or the restrictions that apply to the ECB. And this is an interpretation that was actually reinforced by the member states arguing before the Court of Justice. Because there they were saying that, well, even if we are breaching it, it's the ESM and therefore we're entitled to it. So they were actually feeding, in my view, the idea of the ESM constituting basically a circumvention. That had been, moreover, that had been argued and accepted by the Court of Justice, the High Court in Ireland. The High Court said that that distinction, the fact that the ESM has a separate legal personality, is unquestionably correct and is of crucial significance. And yet what we would argue is that, well, if you're not entitled to do something, you're not entitled to do it. You know, it would be an anathema that member states are going to go outside the Union and recreate customs tariffs and quantitative restrictions as an intergovernmental agreement, either outside the Union or through an entity. So either one isn't allowed or one is. And the circumvention seemed to be exacerbated by certain contradictions. There was this feeling that no bailout clause, there was an argument to support, in order to defend the ESM, you had to say that, well, a no bailout clause does not prohibit bailouts, that the ESM bailout fund is not a bailout fund, that it's not monetary policy, even though it's designed to safeguard the euro, that it's not conferred economic policy, though it coordinates the provision of financial assistance, which is both regulated and prohibited in EU law, that it's not necessary to coordinate the provision of financial assistance within the Union, even though Article 5.1 TFEU says economic coordination to be carried out within the Union, that it's not a Union entity nor a member state, nor therefore not subject to Union law, therefore immune to Article 125, even though it's under decisive control, that in reality it is the member states and subject to the European Union treaties, because that's why Article 273 can apply, because if it really was truly independent, then it couldn't have, the court couldn't have jurisdiction. That establishing a stability mechanism requires a treaty change, but it's permissible to establish the ESM before that treaty change enters into force. I accept that creative reasoning, which is a term used yesterday, has its place as a legal tool and a legitimate legal tool. But there are limits. And, where there are 2 pages of what I would argue are fairly manifest contradictions, it may give the impression that fundamental legal principles become subordinated to political priorities. And what's interesting in this case, and just on a personal level, I don't know how many, and I must finish. A number of people said, this is a really good case. You lose, but legally it's really strong. And I asked, well, how can I explain this in a state of law to my client? My client comes and says, well, listen, I'm really concerned. We're going to set up an institution that is not going to be subject to the Charter of Fundamental Rights, that is imposing conditionality on member states. It's going to be able to dictate economic conditions in relation to pensions, in relation to healthcare, in relation to people's economic and social lives, which are guaranteed in the EU legal order. None of that is going to be covered because it's an ESM, which is an international agreement not implementing union law. Do I have a case? And and in a situation where the treaties actually prohibit bailouts. And I say, well, actually, everyone agrees legally you have a good place, but politically it's a very difficult case to argue. And I just think that in the longer term, the union legal order, is very much based, and this is a question of identity, is based on a shared commitment to its values. We're arguably different member states, different nationalities, different languages, but one thing that we can say is that we share our commitment to our values. And if, even in times of emergency, we abandon those values or compromise them by making arguments which are transparently more political, perhaps, than legal, then I would suggest that there's a danger that would be undermining the integrity of the union legal order and the legitimacy in these founding values which actually bind us together. Thank you for your attention.